Welcome to this edition of Vital Signs and Verdicts, where medicine meets the law and the truth gets put under the microscope. I'm Liam, a former hospital administrator turned whistleblower, and your host. And now I'd like for our panel to introduce themselves.
I'm Hope, a former surgical RN who lived through my own systemic failure.
I'm Pete. I hold a doctorate in psychology and help firms pick juries for high-profile cases.
I'm Dr. Tyler, a medical doctor with a Juris Doctorate. I have testified in federal court and before Congress.
I'm Maria, a former personal injury attorney and White House correspondent.
Tonight on Vital Signs and Verdicts, we're taking listeners inside the newest filings in the Richardson-Edmonds case. Documents now public on the docket. Maria, tell us what we are going to talk about.
The defendants have filed a motion to dismiss, and the plaintiff has filed a response after filing a temporary restraining order and an injunction.
Pete.
This is a detailed response from the pro se plaintiff, meaning she is representing herself. This response is great. It is exposing misstatements of law, concealment of evidence, and an attempt to collapse 11 separate claims into one.
So let's get into what does it mean? What happens next? And why does this matter for every patient and family watching? Now, most people don't speak court, so tonight we're doing something different. For each legal point, you'll hear the real legal explanation first, exactly as it appears in the response. Then we'll break it down into plain English, and then give you a simple analogy so anyone listening can understand what's going on. Let's get into it. Maria.
The defendant's motion to dismiss rests on 4 pillars, and each one is legally defective. First, they misstate Missouri law on preemption by claiming Section 538.210 eliminates all common law claims. It does not. It applies only to claims requiring professional medical judgment.
So what that really means is, they told the court a law does something it doesn't. The hospital is saying there's a medical law that wipes out all of her claims. That's not true. That law only applies when someone is accusing a doctor of making a bad medical decision. It does not cover things like lying in records, hiding records, dropping a patient, giving shots without consent, billing for visits that never happened.
So the hospital tried to use the wrong law to make the whole case disappear.
It's like using a traffic law to get out of shoplifting. Wrong law, wrong situation.
Second, they ignore the standard of review. At this stage, the court must accept the plaintiff's factual allegations as true. Defendants instead ask the court to adopt their own medical narrative.
In simple terms, they want the judge to pretend the plaintiff's facts don't count. Right now, the judge has to assume the plaintiff's story is true. That's the rule. But the hospital said, ignore her story, believe ours instead. You can't do that. Not at this step.
It's like trying to skip to the end of the movie and tell everyone how it ends before anyone watches it.
Third, they exploit their own concealment. They argue the petition lacks detail while ignoring allegations that they altered, deleted, and withheld the very records that would provide those details.
This one's easy. They hid the records, then complained she didn't have details. They're saying she didn't give enough detail. But she says they deleted records, changed records, and refused to hand over the rest. You can't hide the evidence and then blame her for not having it.
It's like stealing someone's homework and then telling the teacher, see, they didn't turn it in.
Fourth, they misstate the law on standing, elder abuse, and fraudulent concealment. These are not minor errors. They are fundamental misstatements of controlling Missouri law.
And here's the translation. They told the court the law says things it absolutely does not say. They told the judge she doesn't have the right to sue. They told the judge elder abuse laws don't allow civil lawsuits. They told the judge fraudulent concealment requires impossible to discover. All of that is wrong.
It's like telling the referee the rules of the game are different, hoping they don't notice. These aren't tiny mistakes. These are basic legal rules, and they got them wrong.
When a hospital files something this misleading, it doesn't look like a legal argument. It looks like an attempt to scare a grieving spouse into giving up.
And medically, none of their claims can be decided at this stage. You need records, experts, and facts. They're trying to skip the whole process.
And that's why the response calls it out. These aren't small mistakes. These are the foundation of their motion, and every one of them is cracked.
We have a text from a listener there asking, so, does this mean the case is over, or does it keep going?
It keeps going. A motion to dismiss is just the hospital trying to stop the case before it starts. But when the motion is built on the wrong law, wrong facts, and wrong rules, the court doesn't throw the case out. It moves forward.
And here, the plaintiff didn't just respond, she dismantled the motion point by point. The court now has a clear record showing why the case must continue.
Here's why this matters for everyone listening. Hospitals don't just fight cases with facts. They fight with paperwork, procedure, and pressure, but the rules still apply. And when a motion is built on misstatements of law, missing facts, and arguments that flip the rules upside down, it doesn't just fail. It exposes the tactics being used. Okay, so let's break this down. There are 13 counts in the original filing. Count 1, medical negligence. Defendants argue count 1 fails because plaintiff didn't identify specific medications, who ordered them, when they were given, or how they breached the standard of care. They also claim plaintiff's own allegations defeat causation.
They're saying she didn't list every drug, every nurse, every minute, but she says the hospital deleted and altered the records, so she couldn't list that information.
It's like burning the recipe and then blaming the cook for not knowing the ingredients.
Count 2, corporate negligence. Defendants argue plaintiff didn't identify specific policies, training failures, or corporate actions. They say she only describes staff mistakes.
They're saying you didn't name the exact policy number, but you don't need to know the policy manual to say the hospital failed to train staff or keep patients safe.
It's like saying you can't complain about a restaurant giving you food poisoning unless you quote their kitchen handbook.
Count 3, wrongful death. Defendants argue wrongful death is limited to section 538.210 and plaintiff didn't plead causation. So they're trying to shove wrongful death into the medical malpractice box, even though the claim includes intentional acts like unauthorized restraints and vaccines.
It's like trying to fit a whole suitcase into a shoebox. It doesn't fit, and it's not supposed to.
Count 4, survival action. Defendants argue survival actions aren't standalone claims, and plaintiff didn't allege she's the personal representative.
They're saying you can't bring this claim unless you're the personal representative, but she is. And she attached the letters testamentary.
It's like telling someone they can't drive because they don't have a license, while they're literally holding the license in their hand.
Count 5, fraudulent concealment. Defendants argue plaintiff didn't plead specifics, who concealed what, when, or how. They're saying you didn't give enough detail about the cover-up. But again, they're accused of hiding the records that would show the details.
It's like someone stealing your wallet and then saying, prove what was inside.
Count 6. Spoliation of evidence. Defendants argue Missouri doesn't recognize a standalone spoliation claim.
So, spoliation in a lawsuit refers to the destruction, alteration, or failure to preserve evidence that is relevant to a legal proceeding. This act can significantly impact a party's ability to prove their claims or defenses, as it deprives them of information necessary for a fair trial.
Courts may impose sanctions to remedy the harm caused by spoliation, which can include fines or adverse inferences against the party responsible for the loss of evidence. To prove spoliation, a party must demonstrate a duty to preserve evidence, the destruction or alteration occurred, and that the loss caused prejudice in the litigation.
Knowing all that, they're right. Spoliation isn't a separate lawsuit, but it is a basis for the judge to assume missing evidence would have hurt them.
It's like a kid ripping up their report card and then insisting their grades were perfect.
Count 7, HIPAA violations, and Count 8, False Claims Act. These were dismissed by federal court right before it was remanded back to Taney County.
Count 9, unauthorized organ preparation. Defendants lump this under healthcare services and do not address the substance. They didn't actually respond to this one. They just said, it's all medical care, and moved on.
It's like being asked, why did you take my car? And answering, well, cars exist. That's not an answer.
Count 10, battery.
Defendants argue this is preempted by section 538.210. They're saying battery, which is defined as an intentional, unconsented touching, is just medical care, but giving someone a shot or restraining them without consent is not medical judgment. It's battery.
It's like punching someone and saying, relax, it was part of your wellness plan. Count 11, intentional infliction of emotional distress. Defendants lump this under healthcare services. They're pretending emotional abuse, fabricated notes, and false accusations are medical care. They're not. It's like calling bullying customer service.
Count 12, elder abuse and patient rights. Defendants argue no private cause of action exists. They're saying you can't sue under this law, but the law literally says you can. It's like telling someone they can't use a coupon while standing under a giant sign that says coupons accepted.
Count 13, injunctive/declaratory relief. Defendants lump this under healthcare services and ignore the spoliation prevention purpose. They're pretending this is about medical care. It's actually about preserving evidence and stopping further record tampering. It's like asking a store to lock up the cash drawer because money keeps disappearing. And the store says, that's just part of shopping.
When a hospital responds like this, it doesn't look like a legal defense. It looks like an attempt to overwhelm and intimidate a grieving spouse. And medically, none of this can be decided at the dismissal stage. You need records, experts, and facts. They're trying to skip the entire process.
And that's why the response dismantles their arguments. These aren't small issues, these are foundational defects.
A listener sent this text. So what is the biggest red flag and why?
The biggest red flag, they never actually address the most damaging allegations. Across all 13 counts, the defendants do something that judges hate and that experienced litigators immediately recognize as a sign of weakness. They never substantively address the facts that hurt them the most.
They mention the counts, yes, but they do not address the fall from the gurney, the fractured wrist, the unauthorized restraints, the unauthorized flu vaccine, the fabricated behavioral notes, the babysitting logs, the private health information disclosures, the billing for visits that never happened, the post-mortem billing, the altered, deleted, or missing records, the organ preservation drugs, the spoliation allegations.
Instead, they lump everything under healthcare services, medical judgment, conclusory allegations, preempted by Section 538.210. This is not a legal argument, it is avoidance.
Our phone lines are back up, and here is Tim from Kimberling City.
Hi, my question is, so since they don't address the most damaging allegations, are they in turn basically agreeing with them?
They are not legally agreeing with the allegations, but what they are doing is something judges immediately recognize as a major credibility problem and a tactical weakness.
The cleanest way to explain it is this. They are not admitting the allegations, but they are signaling they cannot deny them.
In law, silence is not the same as admission. But in motions practice, silence about the most damaging facts is a giant red flag because if they could deny those allegations, they would. If they could explain them away, they would. If they could argue those things didn't happen, they would.
Their failure to address them tells the court, we have no safe way to talk about this without hurting our case. Judges notice this instantly.
Why this is so serious, a motion to dismiss must address each count, address the factual allegations supporting each count, explain why those facts, even if true, don't state a claim.
When a defendant skips the worst facts, it means they cannot dispute them without contradicting the record. They cannot explain them without admitting liability. They cannot argue them without triggering discovery they want to avoid. They hope the court won't notice the omissions. They are trying to reframe the case instead of responding to it.
Courts see this as evasive, non-responsive, lacking good faith, potentially sanctionable under Rule 55.03. It damages the defense's credibility.
So in plain English, no, they're not saying, yes, we did it, but they are saying, we can't talk about it. When someone avoids the most serious accusations, it's because the truth is bad for them, the evidence is bad for them, the explanation is bad for them, the paper trail is bad for them.
It's not an admission, but it's the closest thing you get to one in a motion to dismiss. It's like someone accused of stealing who responds by saying, let's not focus on the missing money. They didn't confess. But they sure didn't deny it, and everyone in the room knows why.
How judges interpret this, judges don't say it out loud, but they think, if the defense had a real answer to these allegations, I would see it here.
When the defense avoids the fall, the fracture, the restraints, the unauthorized vaccine, the FI disclosures, the fabricated notes, the billing fraud, the missing records, the organ prep drugs, it tells the court these facts are dangerous for us.
And that is devastating for them at the pleading stage.
They are not legally admitting the allegations, but they are functionally conceding that they cannot defend them at this stage. And that is exactly why their motion to dismiss is weak.
So here's the bottom line. Count by count, the hospital either used the wrong law, ignored the rules, hid the evidence, or misrepresented what the law actually says. That's why the motion to dismiss is cracking apart. And that's why this case is moving forward.
That is all the time we have for now. We'll keep following every filing, every hearing, and every development, because transparency is how accountability begins. Until next time.